Good morning, good evening, good afternoon. I know it's really late for most of my audience to see this, but they could always jump in later. For those of you who are wondering, I had a lovely Italian dinner. Started off with a bit of calamari. Everybody likes calamari. Then I had the spaghetti with meat sauce, the bolognese. It's, you know, old classic, old favorite. And I had it with steak, delightful. Uh, Probably an 8 ounce sirloin, grilled rare, because why would you ruin a nice piece of meat? And laid out over it. Had a glass of, what's that kind of wine again? Not Bordeaux. Barbera? Something like that. Barbarossa? Anyway, that was a terrible wine. Not really sure. Not really sure why. Normally, that particular style of wine I really like, but this time not so much. It tasted almost like someone poured rubbing alcohol into it. But then for dinner, I had a lovely cheesecake. And I'm a big fan of cheesecake. Fat boys like me need cheesecake. I mean, I know I'm not nearly as fat as BZ Watchdog, but I'm also not diabetic, and I can have the occasional rare slice of cheesecake. Well, what are we doing here? What are we doing here? Someone posted on my Discord this, and this is one of those beautiful situations where somebody fails at reading comprehension. Like they think they got me. They think they found something that I didn't know about. They think they found something that says something other than what it actually says. And oh, Alan, I hope BZ doesn't like eat when he's upset. If that is the case, then I should talk about him if he's the kind of guy who eats while he's upset. But this is for those of you who aren't aware. You can see 10.3 federal enclaves, and you look up here at the top. You see chapter 10.3 federal enclaves. What do you think that this link is? Well, this link is the thing that he was putting up. 3-page document, 1, 2, 3-page document, ends in generally speaking, and 1, 2, 3-page document ending in generally speaking. So it's crazy. It's crazy. It's almost like I even knew where to look. You can say, well, John, maybe you just Googled it afterwards. Well, this is from something that I streamed 12 days ago. 12 days ago, and if you look down here, it says NC Defender Manual, Volume 1, Pretrial. Huh. NC Defender Manual, Volume 1, Pretrial. RA asks if I like my cheesecake with strawberries or naked. Well, first of all, let's define what an actual cheesecake is. An actual cheesecake is baked. It's not one of these soft serve like yogurt in a graham cracker crust kinds of things. It is baked. It is baked. It is solid. You can slice it into a cheesecake. And my preferred topping is plain. I'll be perfectly honest with you. Preferred topping, plain. Um, but this particular one had been like dipped in chocolate with a little bit of whipped topping on top. It was pretty. I mean, it was a little foofy for me, but it was nice. It was a cheesecake. Jimmy Gibbs says 8 ounce steak is the girl's cut. Yes, but I did have it with a full. I'm going really high on my mic here now that I'm looking. I don't want to blast anybody out here. I'm getting a lot of red. Um, I did have it with a full plate of spaghetti with meat sauce. So, you know, when I go to Italian food, when I go to an Italian restaurant for dinner, I am loath just to order steak. I mean, I love steak. I eat steak all the time. I am a carnivore. I love meat. Uh, but when in Rome, as they say, right? But anyway, let's read this. It's just easier for me to read from this. I don't want anybody to think I'm playing games. 10.3 A definition of federal enclave. We have 10.3 a federal enclave. I mean, this is the same document. I hope I hope we're all in agreement. This is the same document, um, but it's just easier for me to read it in this because I can make it bigger, and I'm old, and so it helps me. And this is stupid and cut off. And see down here in 2005, North Carolina General Assembly amended GS 104-7 to give the state concurrent power. He even cuts it off because not only is he incompetent at just about everything else in life, but he's incompetent at taking a picture of, I don't know, the entire document. Now, although maybe I'm being unfair, is there a way to open this up and make it bigger? Open image in a new tab. Does it get bigger? No, it does not. So he's literally just incompetent. BZ Watchdog is fat, lazy, and incompetent. So, but he's going to give me a free education. Anyway, we're going to read this, and we're going to see whether it supports my contention, which is that just because it is federal property, just because there is a federal building on it, doesn't necessarily mean it's a federal enclave. And in fact, it probably in today's day and age, a post office, a relatively new post office that was built after 1940, probably not a exclusive federal jurisdiction area. Probably not, because the federal government doesn't have a reason to do it. And remember, I've shown you just so everybody remembers, it is what is it, 40 USC 33112. Just remember, this is the actual statute. I know BZ Watchdog wants to go to state law. He wants to go to a state source to talk about federal law, to talk about whether or not federal jurisdiction applies. But this is actual federal law. 40 USC is federal law. US means United States, so this is 40 United States Code, Section 3112. The law that this is Public Law 107-217 that was dated August 21, 2002, otherwise known as 116 Stat 1144. Three different ways to find the same law. Three different ways to find the same law. Previously, this was 40 USC 255, I believe, for those of you keeping track at home. But boy, I feel like I'm getting an education tonight from old BZ Watchdog. I love this. For lawyers who do not know about, all of a sudden, I was talking about federal enclaves in the stream. I was discussing federal enclaves at length, and he thinks I don't know about them. That's so weird. Like, he's doubting that I am aware of their existence, and he has to tag me in this. Like, I'm fucking unaware of the existence of a federal enclave. It's strange. It's odd. It's weird. Anyway, so federal enclaves. Although North Carolina ordinarily has territorial jurisdiction over crimes committed within its borders, in some instances, that's language, as lawyers would like to say. Words matter, and this is a document that is written for lawyers. It is a North Carolina Defender Manual, i.e., like a public defender manual. In some instances, federal law displaces state jurisdiction, namely when crimes are committed within federal enclaves. As with any defect in territorial jurisdiction, the defendant may make a pretrial motion to dismiss on the ground that the federal government has exclusive jurisdiction over the defense. So, it happens. Sometimes it happens. And public defenders are aware of it. And prosecutors are also aware of it. Definition. It's going to tell us about definitions. A, quote, federal enclave, end quote, is a building or geographical area within a state that is under the control of a branch of federal government and over which, see, it's not just a building or geographical area that's under the control of the federal government, and is important, and conjoins these two parts of the sentence, It needs to have both. It needs to be both A and B, and over which the United States government has declared jurisdiction. So it needs to be a building, like, for example, a post office, over which the United States government has declared jurisdiction. It can't just be a post office that's owned or leased or rented by the federal government. Federal government must have declared jurisdiction. For example, military installations, federal courthouses, and post offices may, may, may be federal enclaves. Post offices may, not are. That's Eline's position. That's your position. That's not the state of the law. They may be federal enclaves. And for those of you who are keen on U.S. history, or let's say, for example, you're Eline and you're a legal historian, you're aware that North Carolina was a state long before Texas was. Texas became a state much later than North Carolina. North Carolina was one of the original colonies, one of the 13 colonies. Texas became a state much later. Let's Google it. Shall we Google it? When did Tejas become a state? Enter the Union? Sure. Texas annexation. 1845. So, roughly 50, 60, 60-ish years? 70 years. 70 years. Almost 70 years. Yeah. It's late, so you'll have to forgive me, but it's almost 70 years. So 70 years later. So post offices in Texas are much less likely to be prior to 1940 because Texas didn't have a post office for 70 years of time during which North Carolina was a state and Texas wasn't. And you're going to say, well, Texas still existed. Yes, but it wasn't a state. And the post office is the United States Post Office. And so clearly, the United States federal government had not taken land in Texas for post offices before Texas was a state. So, post offices may be federal enclaves. Citations. The government has exclusive jurisdiction to prosecute offenses that occur in federal enclaves. So-called Indian country is not included within the ambit of federal enclaves and is governed by a separate set of complicated jurisdictional rules, the subject of which is beyond the scope of this manual. Establishment of federal enclaves. On federally controlled land, there are three broad categories of jurisdiction. First, the federal government may, there's that funny word may again, have exclusive jurisdiction, meaning that it has the sole power to prosecute crimes committed on federal lands. Second, federal and state governments may have concurrent jurisdiction. I am blowing the hell out of this microphone. It's just screaming red at me all the time, and I don't think I'm talking very loud. Second, federal and state governments may have concurrent jurisdiction, meaning that either government has the authority to prosecute crimes on federal lands. Third, the federal government may retain a proprietary interest only. A proprietary interest only. What a proprietary interest means is that they're only there to really operate a business. A proprietary interest. Like for a post office. Like, we don't really have any interest in making this a federal enclave. We just want to operate a post office here. A proprietary interest. Meaning that the state generally prosecutes crimes committed on federal lands. And again, generally. Why? Because the law is complicated. And if you're an attorney and you're not answering these things with a "it depends," then, well, you're not a good attorney. That's why when an attorney like Eline makes a blanket statement like all post offices are federal enclaves, That's how you know he's a shit attorney. He may do personal injury very well. He may. I would suggest, I would guess he probably does. If he's gotten $150 million in settlements, he probably is a good personal injury attorney. But his knowledge of law and his inquisitiveness, his willingness to look up the law, to read the law, to understand the law, is somewhat lacking. And since he is holding himself out as a legal historian and an expert in these matters, one would expect him to do his best and to show us how good at research and how good his understanding is and how good his ability to find and identify and hold up the correct things. But if you notice, he has not placed a single statute up in any of these fucking discussions on the post office. He held up a agreement between a city and a county to have the county act to enforce the laws within the city, to essentially require a county to enforce the laws within the city. He hasn't shown any statute. He hasn't shown any work. Believe this or not, as fat, lazy, and retarded as BZ Watchdog is, BZ Watchdog, by doing this 10-second Google search, BZ Watchdog has actually done more research and gotten closer to understanding the truth than Eline has. Let that one sink in. Let it sink in that BZ Watchdog is a better researcher than Eline. Or at least he's willing to research. He's bad at it. He comes up with the wrong answers. He doesn't understand what he researches, but he at least found a document that says clearly on its face, the exact same things that I've been talking about. I mean, it's fucking odd that BZ found it, theoretically read it, and doesn't understand it. I mean, that's kind of crazy, kind of weird, mind blowing, as it were. And yet, there you go. There it is. Turn this down a little bit more because my God, my golly, I am just pushing up into the red all over the place. There must be a dog out here. I hope there's a dog out here. Something big just came up behind me somewhere. It is a dog. Hello, dog. Wife must have let the dogs out. All right. So, we're going to continue on. This is page 2. You probably never got to page 2, but this is page 2. The method by which the federal government acquired the land determines the type of jurisdiction. For example, the state may grant land to the federal government. In this instance, the terms of the grant will determine whether the state retains jurisdiction on the ceded land. So this says essentially that if the state grants land to the federal government, the state may give up its territorial rights to enforce its laws on that land, or it may retain them. The federal government may also acquire state land by buying or condemning it with the state's consent. When this occurs, the state retains the jurisdiction to enforce its laws on the land. So, if the federal government rents or leases a corner of a strip mall to put in a post office and doesn't ask the state's permission to do it, it just asks the local landlord if they can rent or lease that space. That's doing it without the state's consent. And when that happens, the state retains jurisdiction to enforce its laws on the land. It's fucking crazy. Is BZ here? Well, Lady Poe says it's BZ. Oh, good for BZ. I don't see him. Maybe he's just blocking me. Last, the federal government may purchase state land or buildings with the consent of the state government pursuant to Article 1, Section 18, Clause 17 of the United States Constitution. Giving consent pursuant to federal Constitution to acquisition of land by federal government for certain purposes. See State versus DeBerry. This is a North Carolina case noting constitutional basis for federal government's authority to assume control of physical locations. When the federal government purchases state lands with the consent of the state legislature, the date of the acquisition is key to determining whether the state retains jurisdiction to prosecute crimes. For property acquired before 1887, the type of jurisdiction depends on the language of the legislative act giving consent to the federal government to acquire the land. So in North Carolina, prior to 1887, it would depend on whether or not the state, when the state ceded the land, or when the state gave the land to the federal government, gave consent, whether or not the state retained jurisdiction to enforce its territorial laws. For property acquired between 1887 and 1905, the federal government has exclusive jurisdiction. So, post Civil War to 1905, the federal government, whatever it took, it has exclusive jurisdiction. This is in North Carolina. Remember, this is in North Carolina. For property acquired between 1905 and 1907, concurrent federal and state jurisdiction exists. It's 2 years. Congratulations. For property acquired between 1907 and 1940, the federal government once again has exclusive jurisdiction. And then during the time periods before 1940 in which the federal government has exclusive jurisdiction, such jurisdiction automatically attached on the acquisition of the land. After 1940, and this says before May 27, 2005, when the federal government acquired land. Oh yeah, in 2005, that's when it stopped being. That's when the federal government, did not have to say we want concurrent, I believe. After 1940 and before May 27, 2005, when the federal government acquired land with the consent of the state legislature, again, this is where the federal government asks the state to cede land to it, not just rents space at a strip mall, not just leases a corner plot of land to build a post office on, but when they go to the state legislature and they say, give us this land, please, and the state legislature says, sure, here you go, the federal government did not automatically obtain jurisdiction, either exclusive or concurrent, over the criminal cases. If you remember earlier today, we looked at Adams. What was it? Adams territorial jurisdiction, 40 USC 255. I think it was Adams. Adams v. United States. Here we go. Hold on a second. Give me the fucking Adams 80. Fat fingering. Adams v. United States. Here is the site to Adams v. United States. This is the one we read earlier. We read this one earlier today. This was the one where there were the gentleman who took advantage of a lady on a military base, Camp Campbell, I think. And the question was, since Camp Campbell was acquired after 1940, or no, it was acquired. Yeah, it was acquired after 1940. So, as lands within a state thereafter acquired under U.S. code, no jurisdiction exists in the U.S. to enforce the criminal laws embraced by U.S. code, yada yada yada, unless and until a consent to accept jurisdiction over such lands is filed on behalf of the United States as provided in such act. So between 1940 and 2005, the federal government did not retain any jurisdiction unless it specifically said, I want concurrent jurisdiction or I want exclusive jurisdiction. And at that time, it would get it. It would have to ask for either one of them. And then post 2005, it has concurrent jurisdiction unless it asks for exclusive jurisdiction. And that's what they're talking about here. After 1940 and before May 27, 2005, when the federal government acquired land with the consent of the state legislature, the federal government did not automatically obtain jurisdiction, either exclusive or concurrent, over criminal cases. Instead, the United States government must have affirmatively asserted jurisdiction over the site. see 40 USC 3112, formerly 40 USC 255, amended in 1940 to require assertion of jurisdiction by the U.S. government. Notice how this document is citing to the same things I'm citing to. Isn't that weird? Do you think BZ understands that? I don't think he does. I don't think he read this, or if he did read it, I don't think he understands it. I think he looked at that first page, and he saw, for example, military installations, federal courthouses, and post offices may be federal enclaves. He read that as post offices or federal enclaves, and he thought he won. He thought, oh, I showed that Murbeast. He doesn't know what he's talking about, except I think it's pretty obvious that I do know what I'm talking about. I mean, I could be wrong. I mean, maybe he will clown me. Maybe he'll pull something out that actually says all post offices are federal enclaves, and the state has no authority to enforce its laws in any post office anywhere ever. But I'm thinking he's not going to be able to find that. Just call it a hunch. Hey, look! State could not prosecute. Oh, these are for murders at Camp Lejeune military installation where federal government purchased land in 1941 accepted jurisdiction. That's State versus Burrell. So Adams versus U.S. was kind of backwards in Adams versus U.S. because the U.S. hadn't affirmatively uh, demanded either concurrent or exclusive jurisdiction over the military installation, the base that was acquired post 1940. They could not be charged under federal law. Whereas in this case, apparently, State versus Burrell, which is a North Carolina case, the state could not charge people and prosecute people for murders at a military base where the federal government had accepted jurisdiction. State court retained jurisdiction over offenses committed at Cherry Point Marine Air Corps Station where U.S. government had not followed statutory procedures to acquire jurisdiction. Look at that. So that's why a lot of attorneys, most attorneys, I should say, all competent attorneys will say, well, it depends. And what does it depend on? It depends on whether or not the U.S. government has has followed whatever procedures are necessary, contacting the governor or whatever procedures the state has set up to assert exclusive jurisdiction over that federal enclave or over that federal property, I should say. And then see this one: state has exclusive jurisdiction over offense occurring in post office. What is this? What is this? Do you think BZ Watchdog read this? Do you think BZ Watchdog read this? This is State versus Graham, 47 North Carolina Appellate 303, 1980. This is the document that BZ Watchdog held out to clown me. He was thinking he was clowning me. And it says in here, state has exclusive jurisdiction over offense occurring in post office. Although federal government operated the post office, record did not reveal that it had accepted exclusive jurisdiction. Isn't that fucking crazy? Isn't that ever loving, ever fucking crazy? We're going to do this. We're going to do this as well. And we're going to open this up. And we're going to go here. We're going to go to Open Docs. I'm going to download that bad mamma jamma. We're going to go to, oops, we're going to go to downloads. And we're going to go to this, and we're going to open with Firefox. Boom. There we go. All right. So another thing that he was talking about, BZ was talking about, by the way, is that he said on this Moore versus U.S. When I read the underlying case, when I read the district court case, I'm like, oh well, Moore lost. I don't know what your point was, and BZ said something along the lines of, I am somewhat paraphrasing. He said that the trespassing was overruled, but the disorderly conduct was allowed to stand. But this is the appeal. This is the appeal from it. And upon due consideration, is hereby ordered and judged and decreed that the judgment in the United States District Court for the Northern District of New York be affirmed. Be affirmed. Uh, Actually, no, this isn't the right one. This is they sought to appeal. Let's see. Uh, so this is apparently a Bivens action. I should have read this before I brought it up. Another attorney had offered this up, saying that this was the one, and I just glanced at it, saying, "Oh, this one in fact was not affirmed." I hadn't read it; I just glanced at it. So, mea culpa, mea culpa. This is for their civil suit. This isn't for the criminal action. This is for the criminal action. But interesting here. There was an order prohibiting Don Moore from entering the Jordan Post Office. Supreme Court held that the existence of a right of access to public property and the standard by which such limitations upon such right must be evaluated uh, differ depending on the character of the property at issue. An independent review of the record indicates the Jordan Post Office is most accurately characterized as a non-public forum, a location that the government is not open for expressive activity by the members of the public. Since the First Amendment does not guarantee access to property simply because it is owned or operated by the government, and the no entry order is based on Don Moore's disruptive behavior, not because of the content or viewpoint of Don Moore's speech or expressive activities, the order limiting Don Moore's access to the non-public forum was a reasonable restriction. But this is non-responsive. I haven't found. I should look at. I thought this was going to be it. Another attorney, like I said, had provided. I thought this was it, but I will double check to see if there was an appeal, a successful appeal of the criminal case. Anyway, back to this. Back to this nonsense. You know what we should do is we should look up State versus Graham just to make sure it says what I think it says. Because why wouldn't it say what we think it says? Why wouldn't it say what we think it says? Defendant was tried on 2 bills of indictment charging breaking and entering larceny, and 1 bill of indictment charging breaking and entering. Several break-ins occurred in Maury, North Carolina on the night of blah, 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 1979. The next morning, the postmaster of Maury discovered that Maury post office had been entered. The glass door was knocked out. 2 record cabinets were opened, the mail strewn on the floor. A safe had been tampered with but not opened. A radio and $20, which were the personal property of the postmaster, were missing. 2 sets of shoe prints were all over the floor on the papers. 2 sets of shoe prints led from the post office to Charles Stokes' warehouse, which had been entered and from which a tire tool was missing. Julian Jones's garage had also been entered, but apparently nothing was taken. Defendant was arrested without warrant at a friend's house after the friend admitted to an investigating officer that he and the defendant had committed the break-ins and thefts. Defendant was questioned and made a statement in which he admitted participating in the alleged crimes. The statement was introduced as evidence of the trial. Defendant testified on his own behalf. He did not commit any of the crimes of which he stood charged. He offered the alibi that he'd been in Greenville the night of the break-ins. He did not know the break-ins until the next morning. He admitted to answering part of the questions on the statement introduced into evidence against him. The jury found the defendant guilty of felonious entry into and larceny from the Moy Stokes store, guilty of felonious entry into and larceny from the Maury post office, and guilty of felonious entry into Jones's garage. Defendant appeals from a judgment imposing an active prison sentence. Defendant brings forward 8 assignments of error in the trial below. We find the assigned errors without merits. Defendant contends the courts of this state were without jurisdiction over the crimes of breaking and entering and larceny from the Maury post office. Huh? Isn't this exactly what Eline and BZ Watchdog are alleging? That's crazy. Congress passed a law to protect the United States post offices from breaking and entering and larceny. That's 18 U.S.C. 2115, 1707. Our state, in compliance with Clause 17, Section 8 of the first article of the United States Constitution, consents to the acquisition of lands within the state by the United States and cedes exclusive jurisdiction, except for service of civil and criminal process over land so acquired, to the federal government. The United States may accept exclusive or partial jurisdiction over lands acquired within a state, and 40 U.S.C. 255, which is the old one, remember, provides that exclusive or partial jurisdiction may be accepted by giving written notice to the governor of the state or in such other manner as prescribed by law of the state in which the land lies of the type of jurisdiction that is being accepted, unless and until the United States has accepted jurisdiction over lands hereafter to be acquired as aforesaid, it shall be conclusively presumed that no such jurisdiction has been accepted. Until the federal government accepts exclusive jurisdiction in accordance with 40 U.S.C. 255, our courts will retain jurisdiction over crimes against the laws of the state committed on federal lands in this state. Citation, citation, citation. The record does not reveal that the federal government has accepted exclusive jurisdiction over the Maury post office property. Defendant maintains we should at least remand the case for determination by the trial court of whether it had subject matter jurisdiction over the post office offenses. Defendant notes that this was done in a Pennsylvania case involving burglary of a post office. See Commonwealth versus Magnet, 231 PA Super 162. We do not feel it necessary because the differences between the Pennsylvania statute concerning the ceding of jurisdiction over lands to the federal government and interpretations given that statute by Pennsylvania courts and our own GS 104-7 concerning ceding of jurisdiction over lands to the federal government and the interpretation of that statute in Burrell. Furthermore, the trial court in this case heard the defendant's motion to this effect and denied it. Remand to the trial court is not necessary as it has made a ruling on jurisdiction. Upon the record of this case, the defendant has no immunity from subject matter jurisdiction of his crimes in our state's court. There is no showing of acceptance of exclusive jurisdiction by the federal government over the post office. I think it's pretty fucking clear. I think it's pretty fucking clear that the federal government has to now, post 2005, the government has to has to tell the state, I am taking exclusive jurisdiction over this property, or else it is not a federal enclave. In 2005, the North Carolina General Assembly amended GS 104-7 to give the state concurrent power to enforce its criminal laws on lands purchased or otherwise obtained by the United States. This provision appears to apply prospectively to lands obtained by the United States on or after May 25, 2005. It was further amended in 2009 to provide that North Carolina's consent is not given to the United States for acquisition of land for an outlying landing field in a county with no existing military base at which aircraft squadrons are stationed. Exclusive jurisdiction over such land acquired by the U.S. is not ceded to the U.S. for any purpose. Generally speaking, the question of whether jurisdiction has been accepted is one of the federal law. If the federal government has exclusive jurisdiction over crimes committed on federal lands, North Carolina is powerless to exercise concurrent jurisdiction. So, there you go. There you go. So this is what BZ thought would own me, and I just found it hilarious. He thought it would own me. You can tell me if I was owned. This part in here, which he didn't read, just effed him in the a-hole. Let's see if it's on his. Let's see if he actually included that on his page too. Oh no, there it is. State versus Graham, 47, North Carolina, App 303, 1980. State has exclusive jurisdiction over offenses occurring in post office. Although federal government operated post office, the record did not reveal that it had accepted exclusive jurisdiction. BZ. I get it. Eline strokes her ego, but he's fucking wrong. He's fucking wrong. He's wrong because you're buying into his bullshit. You're wrong. You're trying to get me gotchas that literally state that you're wrong, not figuratively, not literally in a generic sense of the word, but it literally, in black and white, says you're wrong. Anyway, that's it for tonight. I might stream tomorrow. I might not. I don't know. I don't care.